Hi, this is Rahul Reddy. Along with me is REDDY NEUMANN. We're here live to give you immigration updates. As usual, we do have a Facebook and YouTube live every Tuesday at 5 Central Time. Along with me is Emily Min. Emily, we have a lot of new updates that's going on with the code, with the premium processing, the administration treating. So what are you going to present today?
Yeah, so we're going to be talking about premium processing, what cases can now be filed in premium processing for H-1Bs, as well as whether you should upgrade to premium processing. We'll be discussing several areas of litigation. We have 3 court cases going on that impact employment-based and high-skilled immigration. Those are referring to the H-4 EAD, the STEM OPT for F-1 students, as well as the Unlawful Presence Memo regarding F-1 students. So we'll go through what the latest is in all of that litigation and when you can expect news from that. We're also going to be talking about upcoming visa bulletin, what we can expect over the next couple of months, and answer your questions live. If for some reason we're not able to get to your question or you want more information, you can always join one of our daily conference calls. You can get the dial-in information and the schedule for that by going to rnlawgroup.com. And if you would like more information to discuss your specific situation, you can always set up a consultation with any of our attorneys by going to rnlawgroup.com and clicking on consultation. So first up, we got the announcement that premium processing was going to be back, but only for certain types of cases. Can you give us an update on which cases are now eligible for premium processing?
Right now, only cases which are being filed in the quota, that is in April of 2018, are eligible for the premium processing. That's starting from yesterday onwards. These premium processing are allowed. Even if you have an RFE response due, you can upgrade it when you respond to the RFE. If you have already responded to the RFE, or if your case is not yet due for the RFE or not been adjudicated, you can still upgrade to premium processing at this point of time, only for the new quota cases. Now, you guys might already know that premium processing is allowed for the extension cases, not extension with amendment, just extension. Now, having said that, there are a couple of cases we are still not eligible for premium processing. One is if the person has applied for change of status from H1 from one company to another company, you will not be allowed to do the premium processing right now. If you have filed an amendment plus extension at this point of time, you can still not do premium processing. We're expecting for these 2 kinds of things to have a premium processing to come back on February 19th of 2018. Emily, one thing that there is a rumor that premium processing always gets you denial, premium processing gets you the RFEs. Is that any true in there?
I've really not had that kind of experience. I feel like if a premium processing is going to issue an RFE, it probably would have been issued under regular processing as well. And the same thing with the denial. I don't feel like premium processing is any more strict in how they're adjudicating the petitions. So if it's maybe a weaker case or if there's a weakness in the case, that is what is going to cause an RFE or a denial, not the premium processing upgrade. So I'm a fan of premium processing. I've been upgrading petitions already this week that are still pending from last April. Even those that have already had a request for evidence, I've upgraded a couple of those today. So I think it's a good plan. Most importantly, you want to make sure you get the decision before April of this year, just so that if it gets denied, you have the chance to file again this year. If you don't find out until April 5th that last year's case got denied, well, then you've just lost your chance to file this year. So that's my main reason for wanting to upgrade, so that we can get the result and know what to do, know if we need to file again this year.
Emily, any updates on the litigation on the August 9th memo? I know we've been speaking that if you are on day 1 CPT, you may have some troubles for that, and now you're saying that there's a case filed, court case filed. Can you update on that and what's going on that?
Yeah, so a group of colleges and universities did file a lawsuit against the Department of Homeland Security, basically arguing that the unlawful presence memo from August 9th is unlawful in and of itself and should not be used to find that students have been unlawfully present in the U.S. They should continue with the old plan. So that lawsuit was filed. We've had a couple of briefs back and forth, and the colleges that filed the lawsuit requested a preliminary injunction, meaning that they want the court to suspend the memo from taking effect while the litigation is going on so that students won't be harmed while the court is waiting to decide the case. So they again followed up on that request for the injunction and requested the court to make a decision on that by February 4th, because as we've discussed many times here, February 5th is the 180 days from the August 9th memo taking effect. That's when many students could find themselves subject to the 3-year bar if they've not departed before that date. Now, we did get an order from the court yesterday that they did not suspend the memo from taking effect during the litigation. They only suspended it for 2 of the plaintiffs that are involved in the litigation. So the memo will not impact them while they're waiting for their case to be heard. But for everyone else, every other student who's on F1 right now, this memo is still in effect. The court did not suspend it. And on top of that, the court set March 26th, I believe is the date. March 26th is when the court will have hearings from both sides on the issue of whether the case should be dismissed or also whether they should actually suspend this memo by doing a temporary injunction or a temporary injunction. So there's still a chance that the court could suspend the effectiveness of the memo while we wait for the litigation to wind its way through, but we won't find out until after March 26th at the earliest, which means that those that are currently getting close to the 180 days need to take action still to avoid this 3-year bar being triggered.
Any updates on the H-4 EAD litigation, Emily, and any proposed regulations that you have on the H-4 EAD? The Trump administration has indicated that they are going to take the H-4 EAD off. The discussion has been ongoing, but is there any proposed regulations on that have been published?
Yeah, as of today, still no proposed regulation has been submitted to the OMB. That's kind of the first step that the government has to take when they want to propose a new regulation. On top of that, in the litigation that's ongoing, the court issued kind of a new briefing schedule that delays things by an extra month. So the next round of briefs are not going to be due until March and April in that case, which means we won't be getting a decision anytime in the near future from the court on the H-4 EAD litigation.
On the H-1B lottery system, we did update it last week and we're updating. It's very important information to a lot of people, Emily. In the preceding 15, 20 years that we have been there, there are a lot of times the lottery has been there. When the lottery has been there, we used to file the applications on the April 1st week. That means the first 5 working days of April, we have to file the H-1B application. Now, since the H-1B lottery system, the proposed regulations have been proposed, but they're not finalized. They are now contemplating that they are going to create an online system in which the employers would be able to register the employees, and they would be able to do the online thing instead of filing the entire application. And now once the name is selected in the lottery, they want only those applications to be filed. How far is the proposed regulation? Is it done? Is it not done? If it's done, what are the insights that they need to know? April 1st is not that far. It's just...
Yeah, I think we're 9 weeks away.
9 weeks away.
So we know that USCIS DHS is moving forward with this new regulation that would change the lottery system. They had submitted their final version of the regulation to the OMB, and the OMB cleared that on Monday, yesterday, which means that now the last thing that has to happen is DHS has to actually publish the final regulation. So at this moment, we know that should be coming very near future. We don't know exactly when. They do publish it in advance for public inspection online, so we will have access to the final regulation about a day or two before they actually publish it in the Federal Register. That hasn't happened yet, but it's possible it might be happening by the end of this week or early next week. So once that's actually published, then we'll know what the process is really going to be and can start making plans for how we're going to handle those cases. As of right now, all we know is what the original proposal was. We have no idea what the final rule will look like. We don't know what the time frame would be. We don't know how long the filing window will open for the registration process. We don't know when you'll file petitions. We don't even know if they're going to reverse the lottery process. They talked about doing the order of the lottery in a different way, to do the bachelor's lottery first and then the master's cap as a way to increase the number of master's cases selected. There could even be a lawsuit that seeks to stop this from being implemented, given that it's so last minute, and we don't even know if the reversal of the order of the lottery is actually in line with what the statute says, which was passed by Congress, because they say the first 20,000 should be exempt. So now how are you going to run the lottery of the last 20,000? Is that even legal for them to make that change? On top of all that, even if we do get this system, we have no idea if it'll even work. It's 9 weeks away. We've never done an online filing system through USCIS before, at least not this kind of massive system. It could crash, and so as of now, we're planning on doing everything the old way and being prepared in case there's a lawsuit, in case it crashes, in case they change their mind. So we'll be prepared either way they decide to do it.
So for those people who are waiting for the lottery system to file the H-1B application in April of 2019, please prepare your applications. As Emily pointed out, it's only 9 weeks left. Prepare your application under the old system. If the new system comes in and it becomes effective, you will not be in a loss of filing an application. But if you don't prepare the application and you go, remember that under the old system, which is actually the current system too, you have only 5 days to file an application. If you file an application after 5 days, they will reject it. So that's a good reason for you to prepare the application, make it ready to file. Then if the new lottery system comes in, you can plug into the new lottery system, which is not that bad.
What do you think are some of the, I guess, issues with the way they proposed that regulation? Do you think it's going to make it more likely that people are going to be selected?
You know, having seen some of the other lottery systems that's been there, the H-2B regulations, you know, there were some technical issues there. But they've been conducting the lottery system for the immigration green cards. That's about 70 or 80,000 people are getting green cards through the lottery system. They've been, and the number of applications there are humongous compared to what this H-1B has right now. I mean, we're expecting about 120,000 to about 160,000. So if, and compared to the lottery system they're conducting for the green card applications, the number of applicants are too humongous. I'm expecting success at this point of time, but you know, I want to be cautious though. I want to prepare the application, because if I have taken the responsibility of a client to file the application, I don't want to sit and not prepare the application and then tell the client in the last week, oops, the new system didn't work out, better luck, I'll file you next year. No, that doesn't work for my clients. It doesn't work for me. So I would like to prepare an application ready, keep it ready. If the new system comes in, I will go with the new system, which is not that tough for me to do. But I will prepare it. If the new system doesn't work through, I will file in the old system. I will not wait until April 1st week. I will prepare it right now. As you said, it's only 9 weeks, so it's time for us to work full time right now.
There have been some rumors about more common 221Gs and administrative processing at the consulates. Do you think, are you seeing that, and do you think it's because of the shutdown, or do you think that it's something else?
Yes, there are 221Gs that are being issued at the consulate. I don't think so it has anything to do with a shutdown. The immigration overall is a fee-based thing. So the filing fees that you guys are paying is the one that is running the system. There may be some 221Gs that might have been issued a little bit more, but I don't think so that has anything to do with the shutdown though. It's just a rumor. We have had 221Gs before, nothing new right now that the 221Gs are there. Even though the US government has shut down for about, how many? 5 weeks now? 5 weeks and reopened again. The H-1B and all those related things have no problem because it's a fee-based. The LCA, which is a Labor Department, surprisingly it was funded all the way to September of 2019, so we don't have a problem there. So I would not like you to believe in the rumor because shutdown has affected any of it. You know, they're filing, some of the filing fees we are filing is $7,000. That's a lot of money. This is not a $5 park fees that you pay when you go to the state park. It's a lot of money that you guys are paying. Emily,
yeah, and I think with that, you know, you have to also remember a lot of people just got their H-1Bs approved in this year's lottery. So you have more people probably going for stamping right now than other times. So that could also be why we're seeing an increase. If there's any increase in 221Gs, it's just because more people are applying right now because they just got their approvals.
Emily, if the new lottery system, do you know what the employer need to fill in, or is it guessed right now at this point of time?
Yeah, it's a guess right now because all we know is what they were proposing in the proposed regulation, which was very basic information. Basically, employee name, passport number, date of birth, and that's about it. And then which, I'm assuming there'll be something where they select which lottery they're intending to file under, but not a lot of information would be required according to the proposed regulations. Now, I submitted a public comment for that, and one of my suggestions was that more needs to be provided because there's a higher chance that unscrupulous companies could just go and put in any random people, whether they qualify for the H-1B or not, whether they have a job offer or not, whether they have an LCA or not, whether they're agreeing to the H-1B rules or not, they can just register someone and they could take up a ton of spots. So hopefully USCIS, DHS has taken that into consideration and are trying to fix that to where there's going to be more that has to be submitted in the electronic registration process, but we don't know yet.
One last topic, Emily, that you have written, STEM OPT litigation. What do you mean? If any litigation is successful by the opponents, the STEM extension goes away, or?
Well, so this litigation has been going on since, I don't know, it feels like forever. There was a lawsuit filed regarding the 2008 STEM extension that created a 17-month extension back in the day. And that lawsuit actually resulted in the 2008 rule being vacated. They found that the government did not go through the proper regulatory process in issuing that 17-month rule. So we had about a 6-month period where we didn't have a STEM extension rule. They vacated it, but they held it for 6 months so that a new rule could be done in its place. That is what created the 24-month STEM extension. Now, once we had that, we had more litigation filed, appeals pending. The appeal has now been sent back to the lower court on the idea that, okay, this whole thing, we still have not addressed the overarching issue in the litigation, which is, does the Department of Homeland Security actually have authority to grant employment authorization to F1 students who are here to study, not work? And so their litigation is pending on that issue. It is the next steps in that. We'll see they're having a conference among all the parties that are involved March 1st of 2019. We also have the U.S. Chamber of Commerce has gotten involved in the litigation, as well as the National Association of Manufacturers and the Information Technology Industry Council are all trying to take part in this litigation as well. No, nothing is expected to happen anytime in the near future, but just be aware that that is still ongoing, questioning whether the STEM OPT was authorized in the first place to create that program.
Let's go to the questions in Facebook and YouTube, Emily. Do you have any? Lots of questions coming in for me.
Yeah, go ahead. Mine are a bit delayed.
Going to join full-time receipt H-1B transfer. What is the timeline for the premium processing start?
For a transfer?
Transfer. It is going to be February 19th of 2019. Hopefully so. They will resume it on February 19th. And based on how they did with the new quota, there is a good chance that they might do it for the transfer cases for the premium processing too. Can you work on the receipt notice? Yes, you can work on the receipt notice, absolutely. But of course, people are very scared nowadays with the denial ratings very high. They want to get the approval. So resumption of the premium processing is a very good thing for everybody. I mean, we can have a clear idea what's going on. And also, why not $1,400 for each H-1B premium processing that you guys file, and that's going to go to the government. That's good too.
All right. Anj asks, how early can you apply for the H-4 EAD extension, and whether it's recommended to apply for that along with the H-1B extension? So
yes.
Depends on a couple of things, I think, whether you're filing along with an H-4 or just the EAD. If you want to expand on that.
I have, even though even though the USCIS says that you can file the H-4 EAD application within the 120-day gap period, though, when we have been filing the H-4 plus EAD, they have ignored that rule completely, Emily. Also, when we are filing with the H-1B, and we are filing the H-4 plus H-4 EAD, there are situations where we have filed a H-4 plus EAD application, even if the EAD is expiring 18 months from now, we have filed the H-4 EAD, we have no problem getting the H-4 EAD approval. So I would try to file as early as possible. If the occasion gets in there, file as early as possible though, because nowadays it's taking about 4 to 6 months to get the EAD approval. And then sometimes people are stuck because they don't get the EAD, they don't get the H-4, they don't get the driving license. So it's good to apply when and if there is any rejection that comes out. If you file before 120 days, you can tune in to the Facebook Live and we're going to inform you.
All right. Praj has a question about premium processing, whether a pending motion to reopen or motion to reconsider an MTR can be upgraded to premium processing. No, there's no premium processing for that process. Most of the MTRs are looked at about within 60 days if it's for an H-1B. If the case is actually reopened, it can take a lot longer than that, because then they're going to look through everything again and decide whether to now issue an approval. But there's no way to expedite that process, even with paying premium fees.
I'm going through too many questions on H-4 EAD. Emily, with your question.
Saurav has a question. While you're on an H-1B, can you do other work on the side? And that answer is no, you cannot. When you're on an H-1B, you're only authorized to do the work that's mentioned in your H-1B petition for the employer that sponsored your H-1B petition. If you wanted to do other work, you would need an approved H-1B for concurrent employment to do that other work. So it would have to be H-1B caliber type work, specialty occupation work. You'd need the proper employer-employee relationship and all of that. So you any extra outside work beyond what you're doing for your H-1B employer would be considered a violation.
Repeat question coming. If I'm doing PhD, doctorate degree, and I get the day one CPT, is it legal? Charan is asking this question in YouTube. The day one CPTs itself is where we have a concern. Not just the double masters, it's just the day one CPTs. They are not conducting any classes. If they are conducting anything, it's either once in a semester or once in a month, and that's what we're concerned about. They are issuing EADs without conducting any classes. So day one CPTs only some universities are issuing, about 5 to 10 universities out of the 3,000 educational institutions that are authorized for the I-20s. And we are concerned about these couple of universities, particularly 2 of those universities or 3 of those universities. We have seen probably an enrollment of 25,000 foreign students for the sole purpose of getting CPT. Their intention is not to go and study. And that's where we are concerned that any time these universities can be thrown out of the system and declare all the people who are in there to be unlawfully present in this country.
All right, I had a question about perm processing time. They're currently working on applications that were filed in October of 2018, so you're looking at maybe 3 to 4 months as normal processing time. October is the current processing time on their website. So if your case was filed 3 months or more before October, only then can a follow-up be done. Otherwise, it's considered in the normal processing time. I would mention that if you are going through the perm process and haven't filed yet, prepare for longer time to get the application ready to file, because the prevailing wage determination is taking longer. It's taking about 4 months to get a prevailing wage determination. It's almost longer to get the prevailing wage than it is to get the perm approved.
Emily, the question is coming from Rashmi from YouTube, and this is a question that is that what are you expecting the priority date movements in the spring and going forward? Her priority date is 2011 and her son is 16. Obviously, they are born in India.
Yeah, so we got some information from the chief of the visa unit at the Department of State on kind of what we can expect over the coming months. So I'll kind of try to give you an update on that. Obviously, it's different depending on which category you're in and which country of birth. The most important thing for EB1 worldwide, it's not expected to return to current this fiscal year, and not being current is kind of going to be the new norm for EB1. So just be prepared for that. It is likely that EB1 worldwide in the next 2 to 3 months will move forward anywhere from 0 months to 2 months each month. So between now and May, we could see an advancement of approximately 6 months in the priority date cutoff for EB1 worldwide. EB1, China and India both are being used up very quickly. So we're looking at both of those might only advance about a month each month over the next 3 months. So not a lot of forward movement there as well. EB2 worldwide is expected to remain current for the rest of the fiscal year, which means that we're seeing lower use of EB2 worldwide, which is good for other categories. We get the spillover from there. EB2 India, let's see here, is only expected to move about a week each month for the next 3 months. Very little movement in EB2 India. EB2 China should be moving forward a little more rapidly, about 3 months each month for the next March, April, and May. So that would be potentially 9 months coming up.
So to answer the question, Rashmi, whose son is 16 years old, based on the projections, how the things are going on, since your priority date is 2011, you can expect your son to become 21 before the priority date becomes, so he will be aging out. You may want to, and for a lot of people, that is a big question that's popping up. What do we do? These are on H4 people. There are issues if they were to go to India to apply for the F1 visa. What we strongly recommend is that to apply for the transfer of H4 to the F1 visa 2 years before they turn 21. This is, please note it out, 2 years before they're 21, because the rule is that they have to maintain the H4 status until their F1 status gets approved. And once they turn 21, we all know that they cannot be on the H4, so then the F1 will be denied. That's the reason I want to make a note of 2 years in advance before the kid turns 21. You need to apply for the F1 visa.
All right, Rajesh has a question about OPT ending this summer and what happens if the H-1B is waiting for the H-1B to be approved. So this is where the cap gap extension comes in. If your OPT is ending and you're not eligible for a STEM extension, anytime between April and October, if your OPT is expiring between those dates and you file a change of status from F1 to H-1B in the April lottery and it's selected in the lottery, your OPT is automatically extended through September 30th under the cap gap provision. So that allows you to continue to stay and work until your H-1B is approved, hopefully before October 1st, so that you'll automatically switch over to H-1B on October 1st. Now, if your H-1B is not selected or if it's still pending beyond October 1st, what options do you have? You can change status to any other type of visa you might be eligible for. You can re-enroll in school to continue your studies. However, the number one question is, can I choose a school that offers this day one CPT and start working right away? No, please don't do that. Even if it's going up to a PhD level, I find it very difficult that a university with a solid reputation would be allowing people to work up to 40 hours a week while they're in a PhD program in their first semester. I just don't see that. It clearly, to me, these schools are offering a way of employment with study on the side, not study with employment on the side. And I think eventually these schools are going to find themselves on the wrong side of that, and all the people that are taking part in that could end up unlawful presence, 3-year, 10-year bar. It's just not worth it.
I have a good question from Mahesh Amli. I want more debate on this one. He says that his H-1B extension has been applied with client A. Now he is moving to client B. Should he file an amendment or should he file another extension? I will run this in 2 scenarios. If his I-94 is still valid, what should he do? File an amendment to that client A, or should he file another transfer? He actually got an RFE right now.
Transfer or an amendment?
It was an extension actually. He filed an extension with company A, he filed an extension, and he filed an extension with client A. He got an RFE, but he doesn't have a job with client A, he has a job with client B.
Yeah, if the I-94 hasn't expired yet, I would typically file a new amendment of the approved petition that has not yet expired.
So you're going to file amendment plus extension,
right.
Another application, not file an amendment to the existing application.
Right, I would be amending the approved petition, not amending the pending amendment.
That's right.
That's a mouthful.
Yes, that's right. So instead, file another extension would be an ideal situation if the I-94 is expired. What if, I'm sorry, not expired. What if the I-94 is expired? I'm still leaning doing the same thing, filing an extension rather than filing an amendment to the extension.
Yeah, I think it would be a late filed extension and you'd end up without an I-94.
There's a good chance that you're going to.
Once your I-94 expires, while you're waiting for that amendment plus extension to be approved, you're in a period of authorized stay, but that's not the same thing as being in status. So now when you're filing another extension, you can't prove that you're in status because you're only in a period of authorized stay. So unless the first one actually gets approved, which it won't because the project's no longer there, the second one will be approved without an I-94. It's not a great situation to be in. It'd be a little bit easier if there were consular processing. I might just do a consular processing, premium processing, consular processing amendment, have them go out, come back in with a new visa stamp.
Yeah, most of these problems are created, Emily, because of the premium processing.
Definitely.
If the premium processing would have been there, we wouldn't have been here in most of the situations, though. Hopefully, so on February 19th, the government realizes that they're losing a lot of revenue, so they will come up with the premium processing, hopefully so.
Ganesh asks if you can go to the CBP office to correct an I-94. Possibly. Depends on a few things. The CBP has what's called deferred inspection, where they can correct an I-94 if it was issued by CBP, meaning at the port of entry when you're coming in, if you were given an I-94 with an error by the CBP officer, yes, you may be able to go to the deferred inspection to get it corrected. I've had issues where the reason for the correction was because they put the wrong end date and now the I-94 is already expired. In that situation, it varies depending on the officer and depending on the location. I've had quite a few times where they refuse to issue a correction after it's expired because they feel like you should have caught it and corrected it beforehand. So definitely talk to an attorney in your area to determine whether it can be fixed at CBP or whether you need to travel or file something with USCIS to correct that error.
H-1B extension is due in July. Along with the H-4, can I do premium processing? I'm assuming that when you say due in July is that your I-94 is valid until July, in which case you can file your H-1B extension 6 months in advance. You cannot file the H-1B extension before 180 days. So yes, when you do file the H-1B extension, you can file the H-4 plus EAD. We strongly recommend to keep the H-1B and H-4 and EAD in one application. If you segregate them, what will happen is that they will adjudicate the H-1B in premium processing. The H-4 is taking between 8 months to about 16 months. So your EAD will not be, it expires, so it's always good to keep the package together.
Naveen asks, he's got an approved H-1B with Company A, beyond the 6-year limit, has an approved I-140, filed a transfer to Company B and joined Company B. What happens if that transfer gets denied? Depends on a few issues. So number one, if your petition with Company A has not yet expired and they've not withdrawn that petition and you can go back to Company A for the same job, you can stop working for Company B and start working at Company A the next day to continue to maintain your H-1 status. It gets more difficult if your I-94 with Company A has already expired. In that situation, the denial of Company B's petition puts you out of status and you'll be immediately accruing unlawful presence starting the day following that denial. So you need to exit the country, figure out whether you need to file a new petition, new employer, different employer, same employer, get a new approval, go for visa stamping, and come back in order to get back into H-1B status.
Jay has this question. His H-1B transfer is pending from F1 to H-1. Is it worth going for premium processing? Yes, it's definitely worth for going premium processing because if by any chance you get the rejection, you can still make another application file in the next year's quota, which is April of 2019. For that reason itself, it's worth. Otherwise, you'll be spending a lot of extra amount of money to file another application. It's worth for you to get the result before April 1st of 2019 so that you can decide what you want to do. Under all circumstances, I don't see any reason why I want to wait for the H-1B to be adjudicated. Who knows if they issue an RFE right now, it might take 6 months, 8 months more. I would do the premium processing. I'm an immigrant. I've gone through those steps. I understand. I want to get the premium processing. I don't want to be hanging in the air like that. EB2 to EB3 downgrade question. I'm getting this from YouTube, Emily, is it worth doing premium processing? The priority date is not current. If your priority date is not current, to file the adjustment of status. There are some pluses and there are some minuses going through the EB2 to EB3 conversion. If your priority date is current under EB3 but not current under EB2, we normally strongly recommend downgrading it to EB3. If it's not current right now, it may not be necessary for you to spend all that money. When it becomes current, you can always file the application and you can file the I-140 and adjustment of status application at the same time. We have done a lot of those things in January and December when the priority date was current. So you can do it I-140 and adjustment of status, you can file it. If your priority date is not current, I would not recommend at this point of time to convert into EB2 to EB3 at this point of time. Lots of questions, Emily?
All right, Solarov has a question. His H-1B is already approved with the change of status. Spouse's F2 to H4 change of status is still pending, and now he is considering moving to a new employer and filing a transfer. Will that impact the pending change of status to H4 for his spouse? No, it should not. As long as you are maintaining H-1B status with one company or another, your spouse is eligible for H-4 status. Where it can get a little tricky is if while your H-4 application for your spouse is pending, the first company withdraws the approved H-1B petition, that could lead the officer on the H-4 to wonder if you're still maintaining your status. So it may be necessary to send your receipt notice for the transfer in for that pending H-4 change of status. But theoretically, it should not have any impact.
Question from Rakesh from YouTube. Is premium processing available for I-140 applications? Yes, premium processing is available for I-140 applications. It was never been suspended, at least in the past 2-3 years. It's always there, no problem with that. This question, namely by Hemant, that his salary is a little bit lower, but it's above the prevailing wage, just a little bit above the prevailing wage. Will he has any problem in stamping? In general, we have not noticed any problem in this particular scenario, but as a general, going for stamping has issues. Have we noticed anything peculiar about the salary being just above the prevailing wage? No, we have not noticed anything like that. But in general, going for a stamping is always risky. For my priority to be, Arjun has this question. Given the current scenarios, how long it's going to take for his priority date to become current? February 2015. It was 2007 in 2007. It was 2009 in 2019. So in 12 years, it moved 2 years. Based on that calculation, it might take approximately about 40 to 50 years. However, when I calculated the number of applications inside what is there with the USCIS, how many labor certifications have been filed, it might take a little bit longer than that, Arjun. I'm not happy to say this, but it will take a longer time. Emily and I have authored an article where we said that if you were to file an application in February of 2018, it would take you 108 years for you to get the green card. In there, we have quoted all statistics, the number of applications filed by the Indian nationals, how many number that are waiting in the pipeline in adjustment of status, the priority date up to May of 2010 in EB2 were already filed. We have given all the statistics in the February of 2018 article. A lot of people laughed at us, and then comes this Cato Institute. They laughed at us even much bigger. They said we are wrong by 42 years. That was surprising. They have a little bit more detailed information than we do have. They have a lot more research to do on that. They said it's not going to be 108 years, it's going to be 150 years for the people who are applying in August of 2018 to get the green card. Of course, from February of 2018 to August, there is some timeline, some gap, but there's more information. They put a lot of statistics in there. You can watch that in the Cato Institute on the amount of time. So if you're 2015, I won't have any hope. You can keep on extending the H-1B, wait for any legislative changes, wait for any administrative changes. Otherwise, it doesn't look there's any hope there, Emily.
All right, I think we can take one more question here. And the question, I forget who asked it, but is it better to continue on the H-4 EAD or go for an H-1B? Which one would you recommend? Knowing that the H-4 EAD, we don't know how long it will continue. Of course, the H-4 EAD is easier to deal with. It's a lot easier to get the renewals. It's no restrictions on where you can work or what type of job. You don't have to worry about degree and all of that. But we don't know how much longer it will last. So if you have the option of an H-1B, which of course only comes around once a year, you may want to consider filing this year in April so that you'll have that as a backup plan in case the H-4 EAD regulation is finally published to rescind the H-4 EAD.
I have two clear answers for that, Emily. In the situation, if they have never been on the H-1B, if they are in H-4, I would strongly advise to file the H-1B application, clearly, because H-4 is going to sunset as Emily has described. In situations where you already had a H-1B, you already counted towards the H-1B number, now you are kind of passing your time on H-4 EAD. I would not hurry transferring into H-1B because you can always be transferred when the H-4 EAD is going to sunset. I would not hurriedly transfer because to follow the regulation of the H-1B as compared to the H-4 EAD, H-4 EAD is dead easy. So I would continue in the H-4 EAD if you had the H-1B. Anything else, Emily?
I think that's about it. Thank you so much for joining us today. As a reminder, we're here every Tuesday live at 5 o'clock taking your questions. If you want to get the latest updates, you can go to rnlawgroup.com and view our news. We have lots of articles there with information about what's going on. And you can also go to immigrationgirl.com to get the latest updates and news flashes if you subscribe there. And I answer a lot of questions there in the comments as well.
Don't forget our daily conference call that we do conduct every day for half an hour. You can ask live questions on the telephone. You can get the details of the teleconference on rnlawgroup.com. Thank you guys for tuning in.